topic that I have selected today is principles of public international law. What is public international law? Public international law is a combination of rules and customs governing relations between states in different fields such as armed conflicts, human rights, the sea, space, trade, territorial boundaries, and diplomatic relations. The United Nations Charter sets out the fundamental principles of modern public international law, notably promotion of human rights, the strict limitation on the right to use force against other states, the strict prohibition on the acquisition of territory by force. Now let's have a look at the subjects of international law. States are the primary subject of international law. However, international law can also regulate the actions of other entities, namely international organizations, non-state actors, including national liberation movements and individuals, international non-governmental organizations, and multinational companies. All can be defined as subjects of international law and can be considered as having legal personality. This means that they have both duties and rights provided for by international law. Public international law and the protection of human dignity. Several branches of public international law combine to protect universal values relating to human dignity. Each represents a tool of protection, and all should be considered as complementary and must be applied comprehensively. These branches are international humanitarian law, international refugee law, international criminal law, and international human rights law. What is the difference between public international law and private international law? Public international law comprises a body of rules which is concerned solely with the rights and obligations of sovereign states. For example, the United Nations Charter is a central instrument of public international law. Private international law, also referred to as a conflict of laws, consists of rules which govern relations between private entities and decide which domestic law or courts can adjudicate issues with an international component. For example, if a Chinese company was to sign a contract with the United States, private international law would regulate the applicable law if that contract was violated. It's good to have some kind of knowledge on relationship between domestic and international law as well. The relationship between domestic and international law on the procedural level can be complex, particularly where a national court is applying international law directly. It is important to remember that domestic law cannot be used as a justification for a failure to meet an international responsibility. Sources of international law. The norms and rules of international law are codified in a range of treaties and other materials. The main sources of international law are the treaty law, such as the United Nations Charter and the Geneva Convention, customary international law, established by state practice and legal intention, general principles of law recognized by civilized nations, seen as inspirational rather than direct sources of law. For an example, principles of equity. When we are talking about public international law, it is important to have some kind of knowledge on state responsibility as well. One of the fundamental principles of international law provides that any state that violates its international obligations must be held accountable for its actions. More concretely, according to the notion of state responsibility, states that do not respect their international duties are obliged to immediately stop their illegal actions and make reparations to the injured parties. The principle of state responsibility forms part of international customary law and is binding upon all states. Third, states also have an obligation not to assist other states who are violating international law and have legal duty under Common Article 1 of Geneva Convention to ensure respect for international humanitarian